They don't, and most cities have it on their parents' phone, so not only. So I just think that, like, this is a bit of an important decision where
Or can influence the decision. Yeah. That's pretty vague language, because they might not be the decider, but they can.
It's not,
All right, good morning, everyone. It is Tuesday, October 12th, 2021, and this is the Law and Policy Committee meeting of the California Fair Political Practices Commission. Ms. Lincoln, would you please call the roll?
Commissioner Baker?
Here.
Chair Manich?
Here. Proceed to item number 1, that is public comment for items not on our agenda today. Do we have any public comment? Hearing and seeing none, we'll proceed to item number 2. It's approval of the September 7th, 2021 committee meeting minutes. Commissioner Baker, any edits?
No, I move to approve.
I will second. Ms. Linker?
Commissioner Baker?
Aye.
Chair Manich?
Aye.
The motion passes.
Moving on to item 3, our first substantive item today. This is our legislative development update, and today we have our legislative counsel, Ms. Takano. Good morning.
Good morning, Chair Manich and Commissioner Baker. Last month, I reported on the 5 PRA-related bills that were passed by the legislature, all of which were commission-sponsored or supported, and I'm pleased to say that the governor signed all 5 of those bills. They will take effect on January 1st. And as you know, the legislature is now on interim study recess until January 3rd. Staff has been working on legislative concepts for next year, and I'll go over those ideas today. While I'm queuing up the presentation, I wanted to thank Commission staff for their ideas, input, and technical expertise, including Luz Benetti, Cindy Glazer, Bridget Castillo, and Christopher Burton, as well as the division chiefs and our executive director. Just one moment, please. I'll be presenting it with this view. I hope that looks okay for everyone. Does that work on your screen? No? Sorry for the technical difficulties. We're almost ready. Okay. Great. Thank you to our IT staff. Okay, the first legislative concept comes from the recommendations of the Commission's Digital Transparency Task Force. Looks like it skipped ahead quite a bit. Okay, the first legislative concept comes from the recommendations of the Digital Transparency Task Force. And for anyone tuning in who is not familiar with the work of the task force, the Commission authorized the creation of a Digital Transparency Task Force in the fall of 2019 to conduct research and help navigate a conversation on the transparency of digital political ads. The task force completed its work at the end of July, or in this past July, and its final report is available on the FPPC's website. The report includes two main legislative recommendations, which are to create a state archive for digital political advertisements for the purpose of increasing transparency on the content of digital political ads, as well as who paid for them, and to commission a study essentially on what styles of disclaimers on digital political ads most effectively provide the viewer with information about who paid for the ad. The second concept is one that will also be familiar to this committee, as it was in a bill this past year, AB 775 by Assemblymember Berman. It would require a candidate or committee to obtain affirmative consent before enrolling a person in automatic recurring contributions. The third concept is also one the Commission has discussed before. This is increasing transparency of lobbying activity through better reporting and more informative reporting, as well as shifting the duty to conduct lobbyist audits from the FTB to the FPPC. For improving reporting, staff is looking at adding to what information is reported, such as the names of those lobbied, a description of the lobbying interests lobbied, and the payments received for lobbying. For the auditing piece, I think both staff and the Commission in previous meetings have stressed the importance of these audits and their interest in seeing them get done. This concept will also be familiar to the committee. It was in AB 975 this past year. This proposal would require a Statement of Economic Interests, also called an SEI, also called a Form 700, to be filed with the Commission using the Commission's electronic filing system. And this would apply only to public officials for whom the Commission is the filing officer. This has a number of important benefits. Beyond modernizing the Commission's filing procedures, this proposal would also save staff time and other Commission resources, and would increase transparency by making sure that all of the SEIs filed with the Commission are searchable. The slide includes some ideas or possible options for increasing transparency with regard to committee bank accounts. And this is more about transparency in the context of audits and investigations, as opposed to information that would be publicly available. These ideas are essentially designed to enable Commission auditors and investigators to access necessary bank account records and to increase the efficiency of audits and investigations by requiring clearer designation of committee bank accounts. The long-arm statute would provide better access to out-of-state committee bank accounts. The alternative to this is requiring that committee bank accounts be at an office of a financial institution located in California, but we received some feedback from stakeholders that the long-arm statute would actually be preferable. Number 2 on the slide would require committees to label their bank accounts so that the purpose of the account is in the name of the account. Number 3 would require committees to disclose their committee bank account numbers to the Commission. This wouldn't be public information and would only be used by the Commission. And number 4 would require at least 2 people, likely the committee treasurer and the candidate or the assistant treasurer, to be authorized signers on committee bank accounts. And this is really about making sure that there is someone available who has direct access to bank account records. Currently, typically only the treasurer is an authorized signer, which means that only the treasurer has the ability to access bank account records and statements directly. This becomes a problem when the treasurer is unavailable or unresponsive, and our auditors and investigators run into problems like these, which can result in obtaining only incomplete records, as well as delays in the auditing and investigation processes. And our auditors have also noted that even if a candidate, for example, wants to directly access their own committee bank account records, they're unable to do so if they are not authorized signers. This concept was something that the Commission talked about early last year and actually originated from the Commission itself in early 2019. This would prohibit a state or local government agency from spending public money on a public communication that clearly identifies a candidate or ballot measure, with certain exceptions. So essentially, it prohibits these agencies from spending public money on campaign communications. For some background, other law outside of the PRA generally prohibits public officials from using public resources for campaign activity. But because this is outside of the PRA, the Commission doesn't have authority to enforce that prohibition. The PRA does overlap in one area by requiring these agencies to report a subset of these payments to the FPPC. It requires state and local government agencies to report payments for public communications that clearly identify a candidate or ballot measure. So the Commission can impose penalties if an agency fails to report these payments, but cannot impose penalties for the actual illegal use of public funds for campaign communications. So this proposal would expand the authority of the Commission to impose penalties not only for failing to report the spending of public money, but also for the actual illegal spending of that money itself. This next proposal would give FPPC special investigators access to state summary criminal history information. Investigators in several other state agencies have a similar kind of authority, including investigators at the Department of Real Estate and the Department of Food and Agriculture, among others. Staff is seeking this authority to aid investigators in more effectively and efficiently researching individuals under investigation, contacting witnesses and respondents, and protecting investigator safety in cases where the investigator may be meeting with an individual in person. The need for this next proposal arose once the gift limit was raised from $500 to $520 at the beginning of 2021. The Act currently requires the gift limit to be raised once every 2 years, and the 2021 raise resulted in the gift limit now being higher than the income threshold for conflicts of interest. So this means that there can now be situations where a person can legally accept a gift, even though that gift would create a conflict of interest under the Act. Staff believes that for consistency, the gift limit should not be higher than the income threshold for conflicts of interest, which has been the case up until the beginning of this year. This last slide has a couple of more minor changes to the campaign advertisement disclosure and display requirements. The first would allow committees to include the full required disclaimer on certain digital ads instead of just the hyperlink to the full disclaimer required by current law. The second would consolidate substantially similar advertisement display requirements by combining the requirements for independent expenditure ads paid for by political parties and candidates with other substantially similar requirements in the Act. And that concludes the concepts I'm sharing today. I'd be happy to take any questions, comments, anything from the committee.
Thank you, Ms. Nakano. Just before we get into the various concepts that you've laid out here, logistically, so these are just broad concepts in many cases, and in some of them, like number 5, increasing transparency of bank accounts, the Commission has a number of options. Item 6, with misuse of public funds, there's obviously a bunch of ways we could approach that. So at this stage, you're asking the Commission to give direction on whether we want to pursue these concepts. At what point do you anticipate being able to come back to the Commission with, for more granular guidance, for example, on what options exist under a particular concept and which options we would pursue? And then when do we see language from you? Just can you give us a sense of like the timeline for that piece?
I think we'll be able to flesh out the concepts for the rest of this year, so November and December, and then we will start also developing language probably towards the end of the year for the concepts that the Commission wishes to move forward with.
All right, great, thank you. Commissioner Baker?
Thank you for a good summary of these concepts. I appreciate them. Since this is an opportunity for us to give some feedback, and I'm sure the full Commission will also benefit from that opportunity as well, I'm going to give some feedback. And first, thank you. Second, this will sound like a familiar theme for me, but I give you the reinforcement for it. that as we approach, when the time is right, potential authors, that we have a very strong message. I would hope that our commission would like these to be bipartisan bills as much as possible. And sometimes that means, you know, the principal author won't get everything they want, but and hopefully we get everything we want, but that there are actual members from both sides of the party who are going to be co-authors to the bill, and that'll be something that throughout the legislative process we'd push for. So I reiterate that because I think it's important and usually ends up in better legislation. The other is that if we are approaching potential authors of these bills and they say, will you sponsor it? Or will the FPPC put its name and weight behind it as opposed to just saying we support it? That as we just always have in that upfront conversation, if we choose to do that, we would like to make sure, whenever possible, that we are consulted before amendments are adopted. And potentially, I don't know that this has happened in the last year, but sometimes legislative schedules are very tight and negotiations are made, and you're exceptional at keeping a pulse on those things. But we'd like them to ask us before they agree, if it ever possible, because it might be something that we wouldn't agree with, and then that can change our priorities. So those are the more general global ones, familiar to the commission. I know I've mentioned them before. The feedback I have now is it's a little bit of sense of priority. Certainly item 6, which is the misuse of public funds for campaign activity, is both a easy to understand item, perhaps as opposed to some of the other ones that we see as important, and also really a high priority. So I will, to the extent to which it's helpful for you right now to get priorities, that's certainly one. I think all these are important. Next items is on 5, and this is more for understanding for those in the public who may be watching, and as this continues. One is to just sort of explain that what a long-arm statute is, like what that is, and then also why it's helpful to have potentially these labels on here, a label on the bank account or otherwise. It's both for enforcement, primarily for enforcement purposes, I would think. But if you can take that opportunity to explain that. And that was item 5 on long-arm statute to reach out of state people and accounts.
Sure. So the benefit of the long-arm statute is that, of course, we don't have jurisdiction outside of the state. So if we need to access records, the process is much more difficult and much more costly, takes more time to try to access those records. So really this allows us a more direct way to access them so that we don't have to find a person in state to go through that process for us.
Got it. And thank you for that. I see item 5 in this concept in many ways a time saver. You know, as we look at how our team deals with delay, whether it's a tactic or just there's obstacles that come before us, it's a treasurer that's no longer around, or there's nobody else who can provide the records, or having to go through the process because it's out of state. I think it's good that we are prioritizing ways in which we can cut delay, both for the benefit of reaching justice in cases where it's necessary, but also for the respondents in those matters that are before us. So as that one may not be as high profile an issue that we'll see on the front page of a paper every day, but it's really important for saving time. And then on the first item, the task force, and I appreciate that right now we're just talking concepts. The commission did adopt the transparency task force reports, I want to say in August, so not that long ago. And, you know, at the time I had supported certainly adopting it and keeping that conversation going, and said, hey, when we get to specific bills, I may have a different direction than some of my colleagues. And at this stage, are you planning on drafting legislation that will be mirroring the specific recommendations in the report? And if so, I'd like to throw a couple of concepts out there for discussion, at least with legislators who may take on the legislation.
Yeah, thank you for the question. So I think we're looking at the report as a starting point. Obviously, we don't know what a potential author will think, kind of where it will go in the legislature and what the legislature wants to do with it. So we're considering this a starting point, I think.
I think it'll be more coming in future meetings, since we're at the starting point stage. If there will be conversations with authors, I mean, this is what my encouragement would be. I'll put it out there. I had expressed concern about a state-run database when there may be other alternatives to that. I know the task force looked at that, as well as the content that has to be disclosed in the database. If it's in addition to how much perhaps was spent on a digital communication, but if it includes targeting information, that's where I continue to feel I'm skeptical that adds great public value and maybe helps campaigns more than anything else. So my feedback would be, in the future meetings, if legislators, potential authors, come to us and say, I'm not good with this, if we may consider a more targeted approach, which could be maybe there's a statewide database that you have to upload the digital ads to, but not the targeting information. I realize I've used targeted now in the same sentence, so that makes it difficult, but because that's where I am on this issue is, and we may have some disagreement on the commission, friendly disagreement, but we may also from legislators, and I'd like to early on keep that option open for something that is more focused.
Well, let me just, I just want to interject. I appreciate you reiterating the concerns you've raised previously.
Yeah.
The commission speaks as a whole on legislative concepts, and so to the extent the full commission would like to keep that possibility open, then I think Ms. Nakano would be in a position to do that. If an author independently comes to Ms. Nakano with such a recommendation or suggestion, the expectation would be that Ms. Nakano would come to the commission and seek guidance, and I think that would be the appropriate time and forum to provide guidance on, because then it's not an abstraction, it's actually something more concrete. And so I think, as Ms. Nakano explained, the commission has voted unanimously to approve the recommendations in the task force. That's a starting point. Where it goes in the legislative process, it is hard to predict.
Understood.
At this point. So I think
let's
just try not to get too far ahead of ourselves on that one. It would be my thought.
Good to understand. My only other one is thank you for that. Certainly did vote to adopt the report with my points of concern. I think dissent would be a strong word. This isn't a judicial panel, also publicly noted. The other is, if at this stage you're also I think our guidance, I hope, would be that the two recommendations from the Digital Transparency Task Force could be bifurcated. They wouldn't necessarily be in the same bill. And my guidance would be, I think it's advisable to us to start with that approach. We'll see. Of course, I'm not sure, Chair, your thoughts on that, but I think would be a better bet for us, and important to do.
Yeah, no, I agree. They're two separate. Sorry, I agree. They are two separate recommendations, so two vehicles. Although, again, that's where I think we would start, assuming our colleagues agree with us when this comes to the full commission. But of course, if an author requests that we consolidate those, I think we'd have to take that up at that time. So at least as a preliminary standpoint, I think this committee would recommend that they be bifurcated. But again, let's wait and see what our colleagues have to say.
Thank you.
And I just had one more after that, and that was one of these, item number 2. We had some discussion about the 2-year bill concept. Are any of these concepts that are here, including item 2, ones that would potentially have to move on a different track or a faster track than, again, demanding our attention earlier because of this is going to be the second year of a legislative year? We had some discussion of that, and it may not be significant because one of the bills was a gut and amend in the Senate, I think it was, so it's already passed the House of Origin. Is there anything on here that is on a more urgent schedule that we understand by virtue of the legislative calendar, just for us to be aware of?
I don't believe so. The most likely bill that would move forward as a two-year bill would be the recurring contributions bill. And as Commissioner Wilson noted, because it passed through both houses and was a gut and amend, I think we have a longer time frame than we would otherwise with that one. But we do hope, I think, the Commission has expressed that we take that up early as opposed to later.
Thank you. Thank you for the work. I know a lot will go into this, and we're looking forward to seeing where it goes. So thank you.
Yeah, just following up on Commissioner Baker's questions about the recurring contribution bill. Correct me if I'm wrong, but my recollection was that the author of that bill represented to you that this was going to be a priority next year, and that in fact they were going to make it an urgency bill. It is possible that I'm misremembering that, but Ms. Nakano, is that correct or no?
That aligns with my memory as well. I believe That's what the Assembly member communicated at the time that he made it a 2-year bill. I've reached out to staff on the bill, and we're meeting this month to go over kind of where it is and what the plan is. So I can provide an update when I have one there.
Well, that's very helpful. I appreciate that. I do think that that should be one of our priorities for the end of this year and very early next year. And part of that is, accepting the representation that this would be an urgency bill next year to go into effect immediately. It seems to me that we would want that to go into effect as early as possible next year, so that it is in place for both the primary election and the general election. I think in general, our preference here has always been that we don't change the rules in the middle of the game, so to speak. And so if we're to do this bill, then I think trying to get it in the books before the primary election or in time to apply to the primary election should be our goal going forward. Right. Otherwise, great job, as always, Ms. Takano. Appreciate it.
Thank you.
All right, thank you. Do we have any public comment on Ms. Nakano's report? That is item 3 on today's agenda. Hearing and seeing none. Thank you, Ms. Nakano. We'll see you on the 21st.
Thank you.
We'll now proceed to item number 4. This is our Behested payment reporting regulations, and we have Senior Commission Counsel Karen Harrison with us this morning. Good morning, Ms. Harrison.
Good morning. Give me just one moment. I'm also going to do a PowerPoint presentation, and so I'm going to share my screen.
Excellent.
It's not sharing. So here we go. Sasha, I'm having the same problem where it's not allowing me to do a presenter view. Was there a way that you fix that? It's not giving me the option to. Something you can do on your end? There we go. So I'm going to proceed. I don't have the right view, but that's okay. We will just we'll just deal with this. There we go. Magic. Thank you so much, Sasha. All right. Good morning. Karen Harrison, Senior Commission Counsel, here with the Legal Division. I'm here to present the proposed regulations addressing Behested payment reporting issues. I am doing a PowerPoint presentation this morning primarily to help assist us to go through the organizational structure of Behested payments and the issues that these regulations are concerning. Also, just with the mask on, I think it'll be helpful to transmit information. These slides aren't intended to be dispositive. This is general information. So with that said, we'll be presenting an overview, the issue areas that have been identified that are of concern for regulatory action, and then the proposed actions. And these are proposals that have been before Law and Policy, the first 3 regulations. The last regulation that we'll be looking at, 18.424.3, has not yet been before the Law and Policy Committee, but it has been before the Commission. And all 4 have been before the Commission for pre-notice discussion. Some of the language reflects that discussion and some of the issues that were raised, and so we will be noting that in the presentation. So as a general matter, we're talking about payments involving elected officials, and under the Act, these fall under 4 basic categories. The first is contributions, which is generally understood to be payments for a political purpose. There's income, which are payments to the official, typically thought of as wages or salary. A subset of income, which is gifts, that these are payments that confer a personal benefit to the official. And then there's behested payments. And when we're looking at elected officials, we're talking about a payment made at the behest of the official for a purpose other than seeking or holding elective office. And it's important to remember each category has its own reporting scheme and may have its own limitations that are applicable. So what is a behested payment? Section 82004.5C is the section that we are looking at, defining a behested payment in terms of an elected officer or PUC member, which we refer to throughout this presentation and in all the materials as the official. This is a payment made at the behest of the official where it's clear the payment was made for purposes unrelated to the official seeking or holding elected office. And then that term, it's going to show up, there we go, made at the behest of is defined in a separate statute, 82041.3. Made at the behest of is a broad definition that the legislature has given it. It's a payment made under the control, direction, cooperation, consultation, coordination, and so on, request, suggestion, prior consent of the elected official. The important thing to understand is there's a broad set of actions that fall under made at the behest of. And made at the behest of is used in other contexts under the Act. So here we're specifically talking about the context of an official making a behest for payment where the purpose is clearly unrelated to seeking or holding elective office. So the legislature has explained in section 82004.5C the types of behested payments that fall within this category. And these are presumed not for seeking or holding elective office. These are payments made principally for personal purposes, which may be reportable as a gift, and payments made principally for charitable, legislative, or governmental purposes. It's the latter type that we're talking about today in these proposed regulations. These are the type that are reportable under 84224 and the topic of our discussion. So, just to talk about the requirements for reporting in 84224, these are filed by the elected official and PUC members. They are filed when the payment is made at the behest of the official, and it's made principally for charitable, legislative, and governmental purposes. They're filed within 30 days of the payment from a single source, meeting or exceeding $5,000 in a calendar year. The idea being that that is a significant level that the public needs to be informed of. And I would just want to note that all subsequent payments, once that threshold is reached, any amount after that time period within the calendar year by that single source must also be reported. And the idea behind this reporting requirement is to provide public with information about a significant payment transaction involving the official where there's a potential for influence. And to talk about what gets reported, the reporting requirements under 84224 is that once that threshold is reached, within 30 days, the official needs to report, and the report needs to contain the name of the payer and address, the name of the payee and address, otherwise identify the parties that are involved. The official's name is also on the report, the amount of payment or payments, the date of the payment or payments, a brief description of the goods or services provided or purchased, and a description of the specific purpose or event. So basically, this report gives you a sense of the transaction. Through the last year, the Commission has taken a look at the behested payment reporting requirements and ascertained that there are particular areas of concern. There are 4 areas of concern. And one of the questions that's come up before the Commission and at Law and Policy has been the authority of the Commission to address these concerns. So the Commission has authority to adopt or amend rules and regulations in order to carry out the purposes and provisions of the Act. And generally, just to look at the big picture, the purpose of the Act's reporting requirements are important here. They're to inform the public. to avoid improper influences, disclose financial interests, avoid conflicts of interest, and inhibit improper practices from occurring. And then specific to Section 84224, the Commission has interpreted the reporting purpose of this particular part of the Act is to capture payments of interest to the public, given the official's role in the transaction, and provide disclosure when there's a potential for influence. So the Commission has taken a look at the areas of concern and given direction that regulatory language be proposed that addresses the areas of concerns with a specific mindset, and that's to promote timely, informative, accurate public disclosure of behested payments and not discourage the important service that these payments provide in charitable and governmental context. So there are 4 areas of concern that have been identified, and this slide that we're on right now talks about the first 2 areas. The first one is a relationship concern, and that is where the official has a relationship of control or employment with the payee charitable organization. The second circumstance is where the payor has a matter that's coming before the official's agency. So that's one category. The second category is understanding that the way Section 84224 is drafted, the official needs to file a report within 30 days of that threshold being met, but the official may not have the exact payment information by that filing deadline. What can the official report in that situation? The next area of concern identified is payments that result from a charitable organization's solicitation for a fundraiser that involve the official. We have a regulation currently that addresses that. My slides are somehow moving of their own will. We're back on reporting issues with 3 and 4. There we go. Thank you. We have a regulation, 18215.3, that addresses this issue right now. Through our process of examining the reporting requirements, it's been made clear that we could have some greater clarity in this particular area. And then the fourth category are payments that are made by a sponsoring organization from a donor-advised fund at the donor's direction. And don't worry, we'll be just doing a brief overview on what that donor-advised fund involves. But basically, this has raised the issue of who needs to be disclosed in order to identify the payor in this situation where there's complications on who's actually making the payment, and how do you identify who's the single source of that payment. So these are the 4 areas that these proposed regulations address. So the first proposed regulation, and feel free to stop me if you would like to. My plan is to go through all 4 regulations, and then we can go back and revisit and talk about each one. But if you feel a burning question come up, I'm fine stopping after each one and going through it. I realize it's a lot. It's a big package, and so whatever works best as we walk through this. But that's my plan. So proposed regulation 18424. This is to ensure greater transparency with a brief description of the relationships involved, where you have a relationship between the official and the payee in the first instance. And so this is a brief description limited to the extent that the official knows this information, where the official, their immediate family member, is a founding member, a salaried employee, an executive board member with the nonprofit organization. And then through discussion at Law and Policy Committee, as well as with the Commission, there was the request that we also draft additional language that would have that reach to where the official, their immediate family member, or their executive campaign or executive office holder staff member is in one of those roles, and that we expand those roles to include also serving on an honorary board with the nonprofit payee or serving on an advisory board. So we have optional language there for discussion and for determination, and so we will go back and revisit that after we go through the rest of this regulation. The second part of this regulation governs that area where there is a relationship of sorts between the payor and the official. And this is where the payor of a behested payment is involved in a proceeding that's before the official's agency either at the time the behested payment is made or within the past 12 months. The regulation goes on to define what is meant by a proceeding, and this follows standard conflict of interest language, where a proceeding is defined as a contract, permit, entitlement decisions, but does not apply to general legislation. And the language follows the definition of non-general legislation, which is defined under the Act. And then further defines what does it mean for a proceeding to be before the agency. And here it would be placed on a formal agenda or a matter that the official knows has been submitted to the agency for a decision. These brief descriptions will inform the public. Again, these are not relationships that are prohibited under the Act. So this is for disclosure purposes, so that the public has a better sense of the payment transaction, its purposes, and the parties involved. The next regulation is the Good Faith Estimate Regulation 18424.1. This allows for a procedure for filing a behested payment report with estimated payment information. And originally as drafted, it was for payment amount, and our own staff that processes these forms came to us after the last hearing and said, you know, often when the payment amount is not known, the payment date is also not known. Could you expand that to include estimated payment amount and estimated payment date? And that makes sense to us, so that's something that we can discuss further, but we have drafted the language to include that information. And here there's 3 requirements in order for an official to be able to utilize this good faith estimate reporting, and that's that the official must have practiced reasonable efforts, plural, and is unable to get the accurate information. So the official needs to do that up front within that 30-day filing time period. Then the official states in the report that the estimated payment reflects their best efforts, and that the reason why the payee is unable to provide payment information. I'll talk about that a little bit more in a minute. And then next, the official needs to file an amended report within 10 days of receiving accurate information. So if an official does these 3 things, they are not going to be running up against a fine for failure to file or failure to timely file, and there will be a nice package of information for the public, for our commission, for everyone to understand what's going on in this situation, that the official cannot get the information. They have made reasonable efforts to get the information. They've also made best efforts to do that estimate. And then that when they do get the information that is a result of that earlier effort, that they file in a timely manner in that 10 days. So it's really pushing those efforts on the official to be within that 30-day time period. And that's to respond to some questions that were asked before of, you know, how much effort does an official need to make to follow up on this? And the idea is that those reasonable efforts should really come up front in that 30-day time period. Originally, as drafted, we did not have the language that requiring the official to state the reason why the payee is unable to provide information. Staff has reviewed this largely in response to questions and comments about the process and how you get closure and how do you know when you have to follow up, and should we put a time limit on that? And we felt that the best way to address that was by having the official state the reason why the payee is unable to provide this payment information. It could be that it's a timeliness issue, that the payee was unable to process the payments within a certain time period, and that disclosure will let you know that the information is going to be forthcoming. That would be the expectation of the public in looking at the report. In contrast, if the payee, for example, lost all their data in some sort of natural disaster, it would be understood that that information is just going to have to rest with the best estimate. And so our thinking is that this sets up a situation where you get as much information up front, require the effort up front, and the 10-day time limit to report once you receive the data is still a duty of the official without creating additional stages of reporting requirements. and Commissioner Baker, I want to be short because I know that this is something
Sorry,
that you were very interested in. So we're hopeful that this addresses some of those concerns without creating a cycle of reporting requirements. So that is our hope, that this will facilitate timely reporting, provide a clear process, provide the public with the information that is really pertinent to this filing, and then requiring the amending with accurate data.
If it's okay with the chair, since we're right on that spot, may I first make a question?
Sure.
Thank you. It's also a comment. Thank you for really trying to thread the needle. No easy thing to do. It's not apparent from the language, but I would like to know your understanding of this. The official for 30 days has gone through their effort to, hey, how much did you get off of this event that I told people they should give to, or something, right? They've done the ask for the information. 30 days has gone by. The organization says, right now we don't have everything, hasn't been received in hand yet, we don't know yet, but here's the best estimate we can give you. I understand that we have this need to file an amended report within 10 days of getting that information. We're not really requiring that the official's saying, you need to get that information to me when you've got it. Eventually so the 30 days has gone by with the nonprofit organization. The official, are they expected to say, okay, when you've got it, please let me know? I'm anticipating needing clarity on that. Like if there's going to be an advice letter that comes out later, having to say, after that 30 days has gone by, you don't have to keep asking them, but it's got to be clear to the organization that they circle back with the elected official. So something's got to trigger the 10-day time period. And I don't know how else we could write it to say, make sure you tell the nonprofit to follow up when they eventually get it 2 months later. Are you anticipating that's what we have in mind, is that the official doesn't keep asking the nonprofit organization? It's up to the nonprofit at that point.
So the answer is yes,
Okay.
with this clarification, and that's that the reasonable efforts, the suggestion in the regulation is that reasonable efforts include a written statement stating that this information is required. And so then once the official can demonstrate that they've made reasonable efforts, and they are welcome within that 30-day time period to circle back around as many times as they feel is reasonable in the circumstances. Mm-hmm. So that could be a situation where it would be reasonable for the official to ask again. That would be that reasonable effort definition. Mm-hmm. And then once that has happened, it almost feels like you're getting into the realm of, well, this is your second notice. Well, this is your third. This is your final notice. We really, I don't think we want to put the official in the role of a creditor. Mm-hmm. If they have sent a written statement saying, I need this information and I need it by this date, and if you don't have it by this date, I still need it. That's
that last sentence that I'm asking.
Okay.
Is it that says, if you don't have it by this date, I'm still eventually going to need it?
So maybe
that almost ends the back and forth. It leaves it with the organization quite clearly. Mm-hmm. After 30 days, you still need to get back to me when you've got it.
Well, can I
yes.
interject here? Because I think in a perfect world, that is how
yeah.
it would go. But here, the fundamental problem is that the Act does not confer any jurisdiction on us to require the payee to provide that information. Mm-hmm. And so the only requirement under the Act, and we are bound by the statute to the extent that we're talking about what we can do by regulation, we have to stay within the four corners of the statute. Mm-hmm. The statute doesn't allow us to require the payee to actually provide that information ever to the public official. That's the problem. And so the reasonable compromise, and reasonable in my view, compromise that we've struck here in this proposed regulation is we're requiring the public official to do everything that they can within 30 days, the reasonable efforts to obtain the information. And I would imagine they would say, I do need this within 30 days. That's clear from the reg. But the fact remains that if the payee never provides that information to the public official under the existing statute, we cannot enforce that. We can't penalize the public official. We cannot penalize the payee. We are bound by the statute. Is that correct, Ms. Harrison?
Yes, and I think that that's where stating the reason, if the reason is payee was uncooperative and, refuses to turn over information, all of that is really helpful to have in the four corners of the report.
Sure.
Because it's it's giving you a sense of what this official has tried to do and the point that the official is at. I think that it also will assist us in data gathering and potentially working towards solving maybe bigger problems of identifying particular payees that might be at issue and letting officials know, these payees are not cooperating in Behest payment reports. You might want to think twice before you engage in this practice with this payee, or there could also be other means of addressing systemic issues, perhaps.
Like amending the statute, for example.
Yeah.
I mean, but until we have the data, we don't have our heads around how big of a problem this is, I guess.
Well, it's important to underscore that's one of the benefits of these regulations is for the first time we are, a long time, we're going to be able to have that, not only bring some transparency, but have some real concrete examples.
Mm-hmm.
So thank you. I guess where I'm going, and finally, to let you move on from this, understanding the chair's good point that we can't require the I'm going to call it the nonprofit, to do something. Can we require, and should we, and are we requiring the official to add that last sentence that you mentioned, which is, and I will still need this even after 30 days? Can we require them to do that? Which takes away any vagueness about the fact that when that information is available, it should come to the official, so this 10-day reporting period could kick in.
So, all right. One comment that I would make is that earlier in this process, prior to your joining the commission, we reviewed the Form 803, and it comes with written instructions. And one of the suggestions that actually came out of enforcement was, could we propose a sample letter that the official would send? And that letter would state, these are my requirements. This is the information that I need. This is the time period that I need it. And so we were thinking that is something that, as part of this regulation, could be added.
Okay.
So I don't know if that addresses your concern.
It doesn't have to go in the reg, but we can provide a sample gold standard letter. And maybe that's where that is, and that's my feedback from this commissioner, is I didn't do Behest payments, as I've mentioned before, but I can imagine sitting there and thinking, okay, I don't have the information from the organization. I know the 30 days has gone by. I've done my efforts, plural. Is the nonprofit clear that I still need it, or does it just kind of maybe they remember to tell me a month from now? And it's good to have that as clear so that there isn't wiggle room. Some sort of, I don't know that it would happen as a wink, wink, nod, nod. It would almost be, because nonprofits are stretched for staff and compliance. So thank you. The sample letter might be the best place to do it.
Yeah, I agree with that. I remember that from the earlier presentation. I think that's a fantastic idea.
Thank you.
We also discussed frequently asked questions, attaching those to the form as well, and so that's something that could be addressed in a frequently asked question.
Thank you.
So, since we're already talking
Sure.
about it, I had a couple. Paragraph A, the second to the last sentence on line 8, and this is a simple question. We were saying that the reasonable efforts include sending a written request. I assume that written request includes email.
Yes.
It is not. We're not requiring somebody to send a paper wet signature letter, although that I think they should probably explore multiple avenues. But I just wanted to be clear that if somebody was communicating by email, as many people do today, that would satisfy the regulation.
Yes.
All right. And then the second comment / suggestion I had is in paragraph B, and it sort of gets to the issue that we were talking about earlier about what happens when the payee doesn't provide the information and the public official is still trying to comply with their obligation to file a report within 30 days. And the way paragraph B is written is, as I understand it, the public official would be stating that the reason that the payee, charitable organization, is unable to provide the information. And I guess my question is, if the charitable organization isn't being responsive, how would the public official satisfy that? Because you're asking them to state the reason that the charitable organization is unable to provide the information. And I wonder if perhaps a different, maybe better approach would be and state the reason why the public official / PUC member is unable to provide the information. Because then that would give the public official the opportunity to say, I have requested it, it has not been forthcoming from the charitable organization. Otherwise, they're sort of speculating why the charitable organization isn't providing that information.
Okay, point taken.
Agreed.
All right. All right. Well, those are the only two little points I had on that one.
All right, thank you. Now, having done that, do you want to go back and talk in detail on the first regulation?
Nah, let's go back to that.
Okay, we'll keep going.
Save that one for last.
All right. The next regulation is 18.24.2. This recasts the existing regulation, 18.215.3's language, and clarifies that being featured in a solicitation by itself does not raise behested payment reporting duties for an official. And so it's important to understand that this regulation addresses a particular circumstance, and that's when you have payments in response to an organization's fundraising solicitations. Actions by the official outside of that fundraising solicitation are not governed by this regulation. So if you were to appear in a solicitation and that's all of your involvement, that would be falling under this regulation. If you're at the event and you walk up to people and make behests, this regulation wouldn't be pertinent, because then the payments would be in response to your behavior. You're making the behest. So just with that clarification, it clarifies that when the solicitation is sent under, and it's the list of items in the previous statute defining made at the behest of, so the payment sent, the solicitation is sent under the control, direction, cooperation, coordination, concert, request, suggestion, express prior consent of the official or the official's agent, and the solicitation features the official. That will raise a behested payment reporting duty for the official. And then the regulation defines features similar to as is defined in 18.215.3, with just some clarification of the language, non-substantive changes. Basically, you're featured in a solicitation when the official's photo, signature, name of office, if their name is singled out in font or display in the solicitation, that will meet the definition of featured. It will also meet the definition of featured if the official is part of a governing body roster, like on the letterhead of the solicitation, and that body has a majority of elected officials. This regulation adds an exemption as a result of our discussions here at the Law and Policy Committee meetings, where an official is solely identified as a guest speaker in the solicitation. And then again, not if the official's role extends beyond that at the actual event or on their own. If they picked up the phone and made a phone call and said, hey, I'm guest speaker, you should make donations to this organization, that would not be covered by this regulation. But if they're solely identified as a guest speaker, the idea is that they're the guest of the organization and they are not themselves making a behest for payment through that action. So this has clarified language that should provide good guidance to officials. This was particularly of issue during the pandemic when it first started. We had a lot of informal advice and formal advice requests coming in this category. And again, it only applies to payments in response to that third-party solicitation. All right, now we move on to the donor-advised funds regulation, and just to refresh our memory, donor-advised funds are a charitable giving mechanism authorized by the IRS. It involves a situation where a donor creates a donor-advised fund with their assets placed with a sponsoring organization. When they create the donor-advised fund, the sponsoring organization is the owner of those assets, but the donor or donors or donor advisor retains advisory privileges over that fund. So how it works with a behested payment is the official would make a behest for payment for a charitable cause, and donor-advised funds can only be released to a 501c3 that meets certain requirements of the sponsoring organization. So the behested official has made a behest for payment for a charitable cause, and this particular donor or donors chooses to make this payment, this behested payment that's been requested, from their donor-advised fund. They request the payment be made by the sponsoring organization holding the fund. The sponsoring organization reviews it. If they approve it, they write the check. The 501c3 payee receives the payment from the sponsoring organization with notice that it was made from the donor's DAF. And that notice that it's made from the donor's DAF, the donor could be anonymous, the DAF could be anonymous, the DAF could be named so that it's not readily apparent who the donor is. And so it's raised the issue of what an official needs to disclose so that the public is aware of the parties involved in the payment and determine the single source for that Section 84224 single source threshold reporting requirements. So we have proposed Regulation 18424.3. And one thing to keep in mind is that we have one informal advice letter on this topic, so we don't have a long history of interactions with DAFs. But this regulation attempts to capture the issues that we've been made aware of through this process. So for behested payments from a donor-advised fund, the regulation requires that the name of the payor includes the sponsoring organization, the donor-advised fund, that DAF, the name of the donor, and then there's some caveats on the name of the donor. Because it was raised as an issue that we wouldn't want disclosure of, where there's multiple donors, of perhaps a deceased donor, or a donor that had no ability to make the decision to make this particular payment, we've defined donor here as those who have funded the DAF and have advisory privileges. So that eliminates deceased donors and uninvolved donors that don't have that ability. We would like to see disclosure in the regulatory language of a donor's advisor if that donor's advisor has exercised discretion in making the payments. So you have situations where a donor's advisor might be just a functionary. They might just fill out the form. The donor's really the one saying, this is who I would like the payment to go to. You also have situations where the donor designates that ability to make those decisions to the donor's advisor. In those situations, we would like to have the language include the donor's advisor being disclosed as well as that donor, because the donor still has that advisory privilege and is still making some decisions. So we're trying to capture the decision makers with those three requirements, and also to get the specificity of the players that are involved. The next part of the regulation places a duty on the official to inquire with the sponsoring organization as to the party's identity. And it's important to note that the above information, those three requirements, are to the extent the information is known to the official. So that's recognizing that there's a burden placed on the official, but there's some limits on that burden. But it gives them a duty to inquire with the sponsoring organization as to the party's identities. For determining single source for the reporting thresholds, where there's multiple donors, each donor identified would be a single source for an equal share. So I believe that there was a hypothetical where perhaps there was a $15,000 payment coming from a donor-advised fund, and there were three donors who were making that decision to make that payment. You have three donors with that advisory privilege. You would split the $15,000 equally between the three donors. Each donor would be named, and each donor would have met that $5,000 threshold. Now, if it was a $6,000 payment, you would not have those donors reaching that threshold. So that can raise some concerns, but that is the best way that that type of situation can be handled, and it is also comparable to how we treat contributions from a joint checking account, for example. Anonymous donors, when there's an anonymous donor, the named DAF will be the single source. When there is an anonymous DAF, usually you're going to have an anonymous DAF with an anonymous donor, to the extent that the official is aware of some sort of specificity about that DAF, the official is to treat that anonymous DAF as a single source. But where the official cannot get that additional information, which will be in the majority of situations from what we understand, when an anonymous DAF and donor are involved, the name of the sponsoring organization, and the anonymous DAF will be the single source. And that could mean that you're getting a lumping in of more than one DAF as an anonymous DAF from that sponsoring organization as the single source. But that is as detailed a specificity as this language can reach, given the anonymity that is permitted in these situations. So this respects the right for those donations to be anonymous with some specificity. It also will, again, start to add data that we can track. And in my discussions with the sponsoring organizations, they don't believe that there are very many anonymous DAF behested payments being made. And part of that duty of the official to circle back around to the sponsoring organization is that the sponsoring organization does have the ability to go back and ask, do you want to remain anonymous? Or would you like to now come forward and give the name of your DAF, give the name of your donor for this particular situation? And apparently that has happened in situations with reported behested payments with DAFs that were not disclosed, where that circling around has come back, because the donor is the one that controls the anonymity. And it's not a blanket anonymity. They can actually designate this particular payment is going to be anonymous, and this payment won't be anonymous. So that language captures the situations that we believe need to be captured, and then the regulation goes on to define terms, sponsoring organization, and donor advised funds, follows those definitions that the IRS has already put forth. Donor is defined as we described earlier, and then donor's advisor is defined as well. All right, and with that, is there any discussion? And I guess we could either go back and talk about donor advised funds since we're there and it's all fresh in our minds, or we can start back at the beginning. Your choice.
All right. Thank you, Ms. Harrison. Commissioner Baker, what's your pleasure?
Thank you. Working backwards is what is that, last in, first out?
Yeah.
So, LIFO. Thank you also for presenting this. Always helpful to have slides, even if there's not a lot of graphics on them. It makes it clear, and just for the clear explanation. On this DAF issue, one of the very last examples you were giving, I just want to make I want to make it even more concrete. It's the situation where it's an anonymous donor, the anonymous DAF, but let's say it's, I'm going to try to invent a name, Central Valley Foundation. There probably is a Central Valley Community Foundation, so I'm sorry about that. It's California Foundation. And so the name of the foundation becomes the single source.
When you say foundation, are you referring to the sponsoring organization or the DAF?
The DAF.
Okay.
Yeah. And so at least so going forward, once they be under the proposed regulations, they become the single source. So that if there's a whole separate anonymous donor with an anonymous fund there, if the $5,000 amount's been triggered, just because they're the single source, will they have more reporting requirements? Will it trigger more reporting requirements because we've narrowed down the single source as this one name, and that might have two people who are totally unrelated but they're totally not anonymous who decide to give to something. If I made that clear, I probably didn't make it more concrete, but that was my hope.
So I'm not sure I'm following your example.
Okay.
So you have a sponsoring organization, and let's just call them California Community Foundation.
Yes, right.
And they have an anonymous DAF that's made a behested payment?
Yes.
Okay. And then there's another anonymous DAF that's also held by that, yes.
Correct. And the two haven't talked, they just happen to be like-minded, and
They will get lumped together.
Okay.
And that's unfortunate, but absent the official being able, and that language keeps that ability alive, that if the official can somehow designate these two separate anonymous DAFs, and again, the official can go back and talk to the sponsoring organization and try to get more information and see if the donor will allow it. But in that situation, those anonymous DAFs would get lumped together. It would, so the threshold would be for that group. But it is limited to that sponsoring organization. So it would be California Community Foundation, anonymous DAFs.
Yeah.
And looking towards the future, if this started to be a problem, I would imagine we would contemplate if there are other means to deal with this. But I would note that currently anonymous payments are anonymous payments.
Yes.
And they're allowed to happen, and the influence that's the concern is less so when it's anonymous, when it's truly anonymous, when the official doesn't know who's making these payments.
Yeah,
That's
so-
very helpful. And
so-
you did make it more concrete.
Yeah, and I was just gonna say, to that point, when you kept saying lump the anonymous, Behested payments together, you're lumping them together under the umbrella of the sponsoring organization that holds essentially and administers those anonymous staffs.
Correct.
And so you could, in theory, I think one advantage of that approach is that you may see patterns of particular sponsoring organizations that utilize anonymous staffs more frequently than others. And so I do think, like, it's a hard problem to address, and I think that's a pretty sensible approach to it, though.
And I would just point out that if it was just the sponsoring organization being listed without noting that it's coming from an anonymous staff, you lose some of the detail information too, because sponsoring organizations can make Behested payments in their own right. And so to collapse that into just under the umbrella of the sponsoring organization, we would lose that information that, no, this is coming from an anonymous DAF or DAFs from that sponsoring organization, separate from decisions they're making.
Thank you. Yep.
Can I ask a follow-up question, actually, now
Yes.
that I'm kind of processing and thinking about sticking with multiple anonymous staffs from a single sponsoring organization? As I just said, I think that's a very good approach. My question, though, is did we look and assess whether that approach would be consistent with the Behested payment statute requirement that public officials disclose the payor, right? Because here's the one thing that I would like to feel confident that we've addressed, is by lumping them together through no fault of our own, we are mixing multiple parties' transactions together and reporting them under a single entity. And is there any problem with that under the statute? I mean, ordinarily, if I made a Behested payment, Commissioner Baker made a Behested payment, we would be listed separately, right? You wouldn't consolidate our activity together. But that is one consequence of the approach that we're taking here. Again, through no fault of our own, they are anonymous and they're choosing to be anonymous. But I'm just wondering if staff looked at that particular issue and feels confident that we do have the ability to take that approach under the statute.
So this is as fine a slice as we could come up with, given the right to make anonymous donations to charitable organizations and the protections that go with that right to have anonymity. This identifies the sponsoring organization, and it identifies that it's coming from a DAF. So there's that specificity. That's going to give information to the public that this isn't just the sponsoring organization making this decision. Perhaps you could add language saying that if it's from more than one anonymous DAF, that should be noted. That could give a little bit more information. But in talking with the sponsoring organizations, they were very skeptical as to whether or not we're really going to see this. That they believe that most payments from DAFs are not going to fall in this anonymous category. So I would like to see what information comes out of this, but specifying that it's more than one anonymous DAF is something you could do if the sponsoring organization were to give you that information. And given my conversations with their legal counsel, I don't think that they would specify that it's more than one anonymous staff. I think they just say it's anonymous staff, and that's all the information we're required to provide.
All right. I think that's fine. Again, my concern was really just making sure that we feel confident that we can take this approach consistent with the statute. It sounds like the answer is yes. We feel that this is the best approach we can take to this issue given the circumstances.
Yeah, I don't see an issue with it. Again, this is disclosure. There's not a prohibition. It counts towards a threshold just for a significant payment, and you're limited to the information that the official can find out in order to get that threshold, and we want to encourage reporting. And so this encourages more information rather than less. And so I think, given the challenges of a donor-advised fund, this is addressing the situation as we understand it right now, and that may evolve as we work with this more.
All right, thank you. One other area that I wanted to ask you about, and that is the donor advisor. And I think what you explained to us before, the hypothetical you gave, was the difference between a donor advisor, and this is in the context of having to disclose the name of the donor advisor as part of the Behested payment report. And so I think the hypothetical you gave us before was a contrast between where the advisor is essentially performing a ministerial function. They're filling out the paperwork, but the donor is the one making the decision, versus where you have a donor advisor who is making decisions, or exercising discretion themselves. And I think that's the part that I just want to drill down on, is when we say exercising discretion, what specifically are we talking about? Are we talking about discretion in the sense that they have not consulted with the donor who set up the fund for that specific transaction, or ever? Because as I understand it, and you probably have more information than I do on this, but I thought that there were some situations in which a donor advisor and a donor may work together to set up a portfolio of potential charitable organizations, around causes that the advisor may make contributions for on behalf of the donor. So under those circumstances, where the donor has already said, I want you to send donations to organizations that support these causes, are we considering the action of the donor advisor to fulfill that intent an exercise of discretion, or is that ministerial?
So that's a great hypothetical, and we had our own hypothetical that we tossed around that was different from that. So it's nice to hear another take on it. The idea there is that we would like to have the name of the donor and the donor's advisor if the donor's advisor exercises discretion. In your scenario, it sounds like the donor has created a list of, these are 5 entities that I would like you to make payments to over a certain time period. And then if the donor's advisor is the one who's actually making that decision, might even actually have been the one that received the behest, then we want to know about that donor advisor, but we also still want to know about the donor. So in that situation, we're capturing both. And as far as the level of ministerial action, I think that that's something pretty nuanced, and it would really depend on the facts. So it's sort of like, is it a ministerial decision? Did you make a decision? Did you act of your own volition and choose that fund? Well, then we would like to know about you. We're not sure exactly how much information the official is going to get from a sponsoring organization in asking these questions. But if that donor advisor played an important role, the public should be aware of who's making that pull of the trigger that causes the payment to be made.
Yeah.
So I think your question is good. I think it's nuanced. I'm not sure that we want to add additional language further defining that term at this time.
Is the answer yes? I take it from that answer, the answer to my question, though, is yes. We would consider, under the hypothetical I gave, that the donor advisor was exercising discretion and that the public official would have an obligation under this regulation to disclose both the name of the donor and the advisor.
My apologies.
Right?
Yes. That would have been the shorter answer.
I was just trying to, I don't quibble with what we're trying to accomplish here. I'm just trying to understand what we mean in terms of discretion in logistical and like the real world, how this plays out, right? I mean, we can talk about it, but we have to, part of this also is trying to be clear to the public officials and the regulated community when the trigger occurs, where they have to include the name of the donor advisor. So that was, you have answered my hypothetical quite well. So
good.
I think it's
yes,
good.
if the donor's advisor is only in a ministerial role, then it's not a significant person to disclose. So yes, any exercise of discretion.
All right. Commissioner Baker, anything else on DAFs?
Not on DAFs. No, thank you.
All right, should we rewind it back to the first reg?
I did have something there. Yep.
Okay,
The first one.
go for it.
Thank you. So thank you for including the option language in Section A about a member, and the language that's written here is their executive campaign or executive office holder staff. I do think we should have a mention of staff, whether it's campaign or office. And I don't know what executive accomplishes for us. I could see someone having a junior staff member, be the one who sits anywhere from a chief of staff to a junior staff member, being their eyes and ears and source of influence on something like this. So that would be my feedback, but perhaps you're in discussion with the team, your colleagues, you found it appropriate to have executive added there. What was the purpose of that?
The idea was for knowledge of the official, as well as on the enforcement side of things. Staff made the comment that it would be very difficult for an official to know if a volunteer staff member, like a low-level staff member, was in this type of position. We were really trying to keep it tightly written to the official sphere of influence, and that would be decision makers, their immediate family, and then decision makers within their staff. And that executive staff is a nod towards that higher level sphere of influence, connection to the official, as opposed to a volunteer in the mailroom who might be employed by the United Way as well. So that was the thinking.
Okay, I can see that, where that almost goes to the size of the office that the official has, like how many staff you have. And I've channeled legislative is the first one that comes to mind, and they don't necessarily have a lot, but they could be staff that choose on their own accord to serve on a nonprofit board and have that connection. With that in mind, executive, I don't know, senior executive, I think I get the intent for sure. And it's the idea that where I was really going with it is the official may not be paid and may not be the one who receives any particular connection, but they've made sure they have their tentacles in it because they've got a staff member doing it. I've made it sound nefarious by saying tentacles, but they've had their connection to it. I think executive is fine. With that in mind, I would keep it. But I do think having a staff, and both campaign and official, is important to have in this. Welcome your thoughts if you had concurred, because I know the option is here, and I think we need to make a recommendation on it.
I agree that it should be, I think limiting it to executive staff makes sense if we're going to go down this route. I think executive office holder staff is more germane in this context than executive campaign staff. So my thought would be if we're going to expand this to include staff, that it be limited to executive office holder staff and not get into the campaign piece of it. And I do think whether it's through a FAQ or frequently asked questions or some other guidance, I think we have to, it's one thing to say this, it's another thing to advise on it and for folks to be able to comply with it, and who counts as executive office holders staff. And that, I imagine that can be a tricky issue sometimes to navigate among staff. And so I just think we need to think through mechanically, if this is what we're saying, what is our intention? Who do we really mean? And then making it very clear within the regulation or in subsequent advice and guidance on who we mean. I presume you mean people like, at a minimum, the ledge director, the chief of staff. Those are intuitive to me. But if you have a junior district office staff member, is that who we're including here as well? Is that executive staff? And if not, where have we said that they are or they aren't?
It's a good question, and we were discussing terms that need to be defined, and then defining terms within the definition, and so the idea of executive staff was that inner circle, the decision-making group that is around the official. And this is for, again, not for prohibition purposes, but for disclosure purposes. And so the official has some leeway to define that, and erring on the side of disclosure is usually favored. If there's some reason why they had a question, they could ask us for advice. Is this a position that should be disclosed? And then we would start to have that record of advice offered. If it became problematic, we could further define it. So those are some avenues that we can go down. But basically, it's that immediacy to the official in a decision-making capacity.
If I may inquire on the campaign I would keep it in, because your campaign staff could be just as close, just as much involved in your political strategy and sphere of influence in anything. If I may, what's the reservation on having campaign staff?
Well, I would ask the question of Ms. Harrison, what the nexus is between the problem that we're concerned about here. And I think I would just go back to your opening statement. I thought you summed it up quite well, where we are concerned with disclosure where there's a potential for influence. And to me, that is most germane and most apparent where we're talking about the relationship between a sitting office holder and organizations which may have maxed out to their campaign and then are trying to influence their official duties. I think when you're talking about campaign staff, you're now one step removed from that process. And of course, they are in some ways intertwined, but I think they are also neatly divided. There's a reason that you have a distinction between campaign staff and your office holding staff and your ledge staff. And so to me, if we are focused on the goal of improving transparency for the purposes of addressing potential influence by office holders, that to me is the office holder staff. The campaign staff is in a different bucket in that sense.
I don't know if that was a question for Ms. Harrison, but I think I see the excellent point. I can definitely see an entity where your campaign staff is just another it's extension of the office holder. It's just they have fewer restrictions on them. They can advocate for the office holder and to vote for the office holder. They are potentially just as tied and close and in proximity to the office holder than an official staff would be. The difference is the official staff is maybe making more recommendations on, here's how we think you should take this position. I would be surprised if a office holder wouldn't also go to their campaign team, and they're almost an extension of them. It would depend on anyone, but I certainly can see how they are an extension. It's not a hill I feel pretty strongly about it, because I do think they're closely tied, but if it's going to make a complexity, maybe we take it to see what our commission colleagues think or otherwise, unless we're trying to adopt them today, but I think it's the full commission that does that.
Right, and so I think that's one I have concerns with extended to the campaign staff. Our colleagues
Sure. Yep.
feel differently. So, and you asked me.
I did ask, that's right. I realize that's out of the usual Robert's Rules of Order, but I was curious where it helps me understand a little bit. From my point of view, they are in many ways just as much an extension. Also on this one, if it's, with the chair's permission, you had the additional option of honorary and advisory board. And for the same reasons, I think that was language that I might have suggested, or you were kind to be responsive to it, because there are major organizations across the state that don't have a board of directors, but they have an advisory board that serves in the same function, and they may have the same determinations about how funds are spent, and some of them are strictly advisory, and some of them are basically a governing organization with a different name. I think that's important to do as well. So that would be my way in on those.
I agree. Option 4, I think we're on the same page with that. I think that's a good addition.
And I don't believe I answered the chair's question, or perhaps it was the question that bounced. And that's what we were thinking when we had campaign staff and office holder staff. And we're basically looking at agents of the official. And the Behested payment, can be made by the official. It can be made by the official's agent. And so that gets us thinking, well, who is within that agency of the official? And often you're talking about campaign staff and executive office holder staff, and who would the official have an awareness of? And so those were the two places that we were looking. And we're also mindful of those categories that we talked about at the beginning, that, have lines drawn between them of, is this a payment for a contribution? Is it for a political purpose? Is it for income? Is it for gift? Or is it a behested payment for this charitable, governmental, legislative purpose? And so we felt that was information in the campaign and the office holder realm that basically puts the official at the end of the payment cycle rather than just being at the beginning of directing the payment, but also perhaps on the end where there might be some control or influence. So that's what we were thinking, that it's something the public might benefit from being aware of in the report, rather than perhaps that not being disclosed in a report and seeming like there's something going on that isn't being disclosed, that there's a relationship that connects the official back to the payment.
I appreciate that, Ms. Harrison. Do you have anything further? All right. I had one final area that I wanted to talk about, and that's, it's in 18424 is B2. And this is where we're describing the proceeding. And I think it's absolutely fair to require the public official to disclose when an item has been placed on the formal agenda. That is clear to everyone. I think my concern is that we have broadened it to where the public official has knowledge of the matter has been submitted to the agency for decision. And I think I don't object to extending it beyond things that are necessarily placed on the formal agenda at the time. What I do have a concern about is the breadth of this language. And so specifically, I'm thinking of an example where you have a city council member and they're aware that some permit is pending before the city manager. And the city manager has delegated authority to approve or disapprove that particular permit. And that council member has absolutely no role in that process, and in fact may be precluded from trying to influence that process or interfere with the city manager's decision by virtue of an ordinance or a charter provision. That's pretty common in cities that they have those types of non-interference clauses. And yet under this language, I think on its face, the public official would still have to disclose that they know about that matter pending before somebody else in the agency who they have no ability or right to influence. And I think that takes it a step too far. I think, again, what we're concerned about is when a public official has knowledge that a matter is coming before them and they have a decision-making role to play. And I think that is the area that we need enhanced transparency. And so I think this language should be tightened to reflect that. And maybe it is something as simple as if the public official has knowledge of the matter, a matter that has been submitted to the agency for decision, and the public official will be involved in that decision-making or has a role to play in that decision-making. I think that's the type of language I'd like to see, something along those lines to tighten that up. Otherwise, it strikes me as a bit too broad. I don't know, Commissioner Baker?
No, I think that's a good point. The fun part will be how to make it more clear, because if they play a role, do they have influence? You're going to have to probably play with those words. Discretion, input, it'll be tricky to capture it, but it's a good point to Kev Cotton.
Yeah. And I think we can look to our conflict of interest regulations governing officials' involvement in decision-making, perhaps where there's a conflict, and come up with some good language that reflects what we have already.
Okay, great. Again, my concern is that whatever staff looks at and comes back with, that it's clear that this is something that the official has knowledge of and that they are going to play a role in making a decision in that proceeding.
All right. Just a point of clarification. So option 4, I'll call it option 4, it's on that item A, and then 1, 2, 3, option 4, just at the end of that subdivision A. That was something that Law and Policy Committee is in agreement on recommending?
Correct.
Okay. And then on the option that's above, just in the opening paragraph of subdivision A, it sounds like there's some agreement as to executive office holder staff, but not executive campaign staff. Further discussions needed on that one?
Yes.
And then further discussion as far as the terminology for executive?
So, yes. Well, I just think that staff ought to be clear when you're presenting it. If there's a universe of folks that you're considering executive, that the commission be aware of that at the time that we consider this for adoption. I mean, that would be my sense.
Is that to give example? You might have a legislator has 5 staff, and it's your scheduler who basically controls is your gatekeeper. Are they considered junior? I mean, we can play this out a little bit, but are you asking, is the guidance that is helpful to you is if we are listing who are potential positions, or tough?
Here's what I would say. Everything we're doing, both here in Law and Policy and at the Commission, when we adopt these, becomes part of the record that somebody's going to look back at in terms of how this is intended to be implemented. And so while I don't, in this circumstance, think that you need to specifically define everybody in the world who is going to be executive staff for purposes of this regulation. I think it would be very helpful if you gave some clear, concrete examples of what staff's thinking is in terms of who would satisfy the phrase executive staff and why. So that somebody looking at this, a year from now, assuming we adopt these, can look back and say, okay, I'm trying to comply with this. Let's see what they said about who's executive staff and who's not. And that could also inform, after the regulations are adopted, what the frequently asked questions may look like, what our advice is, et cetera. So that's, in this circumstance, I'm not looking for staff to rewrite the reg. I'm looking for staff to think about and be very clear on the record what we mean by this.
Very good, thank you, that's helpful.
All right, Commissioner Baker, anything further?
I'm thinking of a statement that you made just a moment ago, Ms. Harrison, about if there's a transaction happens, let's say something is given to a nonprofit organization, and you want to avoid the appearance that there's undue influence or that information should have been disclosed. And one of the things I'll probably think about between now and the full commission looking at these later this month is if that information comes out, if someone is an executive staff or not, if they're an office holder staff member, that might be information that the public would find helpful to know. So if we're going to have to decide what is our guiding light on this. Is it that the information is out there and available to the public for them to do what they think they need to inform their decision? And if that's the case, are we making it more complicated or potentially creating a way in which folks might get around it by narrowing this to executive staff? And I think that's worthy of us as a commission to be considering carefully before adopting them. So that wasn't a question, but it is a comment.
It's something to think about. I agree.
Thank you.
All right, Ms. Harrison, before we open up for public comment, anything further?
Nothing further for me.
All right, let's go ahead and call for public comment on item 4, our Behested payment regulations. Do we have any public comment? Hearing and seeing none. Ms. Harrison, thank you very much for your work on this. I feel like we've been at this for about 2 years now. It hasn't quite been that long, but it's been a long time, and you've done a great job. So I just wanted to recognize you for your efforts in helping us with this.
Thank you.
Agreed, thank you.
Very helpful feedback, thank you.
Thank you. All right, and that brings us to our last item, discussion of items for the agenda does say November 2021 committee meeting. We are actually not going to hold a law and policy meeting in November, so this would be for the December 2021 law and policy meeting. And the main item that comes to my mind is our legislative agenda. Commissioner Baker, was there anything else off the top of your head that you wanted added to the December agenda?
Not to add beyond the legislative discussion.
Okay, great.
Thank you.
All right, do we have a motion to adjourn?
Move to adjourn.
Second, Ms. Linker.
Commissioner Baker?
Aye.
Chair Madich?
Aye.
The motion passes.
All right, thank you, everyone. We will see you next on October 21st.